So my name is Frank Garcia, and I'm on the faculty here, and I teach international economic law, and I'm very interested in the subject of globalization and law. So I'm particularly pleased to be introducing my friend and colleague, Dr. Per Zumbenson, today. And he's speaking on globalization's elusive search for justice, categories, maps, interventions. So these are, to say the least, uncertain times. When every day's headlines seem to bring more distressing news of further assaults on the core values of Western liberalism at home and abroad, it can seem naive, quixotic, even irrelevant to speak of transnational law, global justice, or anything global at all except in elegiac terms. Nothing could be further from the truth. It is precisely when the surface chop on the ocean of the body politic is roughest that it becomes important to sink down far enough below the waves to get a sense of the deeper currents and the constantly renewing, life-giving potential of the open sea. And nowhere is this more important than within the constellation of questions, challenges, and opportunities that our topic raises today. Per Zumbenson is precisely the man to help us towards this longer view. A longtime student of law with a fluency in both the language of concrete corporate and commercial practices and the discourse of the highest levels of legal, philosophical, and social theory, Per is one of our foremost theorists of transnational law and a leading innovator of its pedagogy. Born in Berlin, Professor Zumbenson studied philosophy and law in Germany and France before receiving an LLM from Harvard Law School, followed by a doctorate and his postdoctorate habilitation from Frankfurt's Goethe University, where his doctoral thesis won the Walter Kolb Memorial Prize for Best Doctorate in Law. From 2004 to 2014, he taught at Osgoode Hall at York University in Toronto, where he held a prestigious Canada Research Chair for a decade, first in the comparative and transnational law of corporate governance, and since 2009 in transnational economic governance and legal theory. While there, he received 2 teaching awards and held visiting professorships in Idaho, Germany, Spain, Switzerland, Ireland, Colombia, Australia, Portugal, and Connecticut. In the summer of 2013, Per was the inaugural chair in global law at Tilburg Law School in the Netherlands, and in the fall of 2013, a senior research scholar at Michigan Law School. He joined the faculty of law at King's College London in July of 2014 as the inaugural professor of transnational law and founding director of their Transnational Law Institute, where he continues to carry out innovative scholarship, pedagogy, and academic leadership. His recent books include Reshaping Markets, Rough Consensus and Running Code, A Theory of Transnational Private Law, and Beyond Territoriality, Transnational Legal Authority in an Age of Globalization, all canonical works in the transnational law literature. Throughout, what characterizes his work most to me is a quality which I can only call seriousness of moral purpose. By this I mean that he expects a great deal from law in terms of its capacity to promote human flourishing, even as he never shies away from engaging with the most profound challenges to law's coherence, effectiveness, and normativity that postmodernism and globalization can generate. I think he is exactly the right person to hear from today, and I'm very grateful that he was able to come and for the generous support of the Clow Center and its director, Vlad Perdue, which has made this possible. So, Per Zumbenson.
Well, thank you very much. When I have the pleasure of introducing speakers, I always tend to give an elaborate presentation of why I appreciate their work so much, but I always find it particularly uncomfortable if that happens the other way around, because all of this is, of course, always exaggerated. So thank you so much for the invitation. It's a really great pleasure. And that's also what speakers always say, but in fact, I really mean it. It's a great pleasure, because for whatever reasons, I really enjoy having a dialogue, which I hope this will become, which students that know me a little better say, well, but then he goes on too long. But anyway, so I try not to go on too long. But I also came here with something in my suitcase. So I brought an exaggerated number of slides with me, which I'm happy, to leave to you, of course. I believe that as anybody who has ever worked as an editor on a law review, that the footnotes really matter a lot. And I put a lot of emphasis in footnotes, which I think reflect a little on what we try to have on our radar and what we think the questions are that are raised by the things that go on around us. And so very seldom, I think it's very rare that we find a text that is truly heroic. There are, of course, articles and books that have been written that we like more than others, right? So Nomos, a Narrative by Robert Cover, we like that text. It's canonical. We also like the references, but the text itself is canonical. But often enough, it's really the way that somebody brings together material and says, we have to engage with this material, and in the body of the text, I try to do this, but I'm just, beginning. And that's how I feel this current work is. So it's to put a lot of things on the table and then see whether we can make sense of it. So the title is owed to several years now of me doing work in legal theory in an area that now has become called transnational law. I mean, the term, of course, is much older, but in the last 10, 15 years, more scholars have referred to this either as a new area of research, of interdisciplinary work between lawyers and legal geographers, anthropologists, sociologists, or even as a legal field as such. But I think we all sort of agree that it's not a proper legal field. In fact, if you say that you teach transnational law, then the Associate Dean of all people will, of course, say, no, but what do you mean? I mean, what do you teach? Which law do you teach? What is that transnational law? So that's a challenge, and that will remain so for a while. So I will suggest that transnational law, whenever I now will refer to it, is more of an approach to reflect on law as such. And it's all about contextualizing law, and that's what I will speak about. So what are the conditions under which we meet the law today, under which we look out for different forms of law, and perhaps also try to find new ways of speaking about law towards creating maybe more reliable forms of law. So the context in which one would speak about justice, and that's a term that I very, very rarely use, but I feel maybe we should start doing that again, but without any hyperbolic intention. That context is that of globalization. And so globalization and the law, that is the formula that has been before us for a long time. And of course, many, especially the students, won't remember that 20 years ago when faculty, PhD students, just with their first positions, when they said about themselves that they are globalization scholars, that actually meant something to them and to their epistemic community. It meant very little and rather confusing things to others, but it was unclear what the relationship is between studying globalization and being a lawyer, a legal scholar, a legal practitioner. So the classical account was one done from a public law perspective, which is globalization is a phenomenon or is a set of phenomena associated with developments, huge, large-scale transformations in economic terms, in cultural terms, political terms, had to do with changing shifts of sovereignty, different forms of cultural influences, migration of ideas, migration of people, and trying to make sense of that in a wider, largely political theory connotated context. The relationship to law was often stipulated as one that globalization, this monster, this unruly set of influences, how does it relate to law? So the two unknowns in that formula were always two, globalization and the end. But in fact, we came to discover that so much is uncertain about the law itself that now for the last few years, we've been much more adamant to investigate what we refer to when we speak about the law itself. So if we refer to law, then it's not just that we say, we are a tort law scholar, we're a contract law scholar, or we do company, corporate law, but we try to, and we should actually speak more often about what is the purpose of law? Why do we do law, and what do we rely on the law for? What's the purpose that we try to achieve? So, law, of course, we know it regulates, it governs, and it brings order. It also is to provide certainty, reliability, and security. It is supposed to offer safety and hope, and hopefully a future. But it's also an instrument that we can use, and we can use it for different purposes. And as we've now seen, yet again, we see that all across history, of course, in different times and spaces, it's often an armor and a shield to protect us. And to protect whether that's societal practices, a particular way of being, the law is there to protect that and to create a space in which certain activities can be pursued. It's also then a house to convene in. If you have a legal process that allows for the creation of a dialogue that is protected, and the law doesn't say what the outcome of that is, which already shows us that the law isn't very explicit on its normative content, but the law creates a formal structure that we then have to fill with content. So it's a framework to operate in, and it's a place that we could call our own. Everyone can do that, and it's a refuge to go to. And the importance of that is seen especially when we see that it's in danger. Now, how does justice relate to all of this? So there are many ways to draw on as a lawyer when we want to go to justice. One of the mainstream ones, which is important, because in so many ways it has framed the way that in the West we have referred to major moments of law's crisis and major moments of renewal. So Nuremberg is not just a name of a town in Bavaria where some of the worst things happened in the Third Reich, but it's also the name of a town in Bavaria where the process happened against war criminals with for many very unsatisfying results. But it's symbolic, so it's not just an historical event, but it also has a lot of symbolical impact, which is helpful but also not so helpful because it shapes and influences, but it also limits our imagination. So it was very obvious that Nuremberg took place in order for the world to see and to learn about the atrocities of the Third Reich and to be confronted with them, and also to see what a legal process could do in response and where the limits would be. It was also meant, of course, to provide for a process in which to bring to justice those that had committed terrible crimes. But it also was meant to mark a moment in time that should now set forth a new beginning, so a never again. So Nuremberg serves as a reminder. Now, similar to other pivotal moments in history, you look back at them and then you look at the present and you ask yourself, where are we now? And so today, in fact, very few people speak about justice. And why is that? In some sense, justice belongs in a rhetorical universe that is committed to making large normative claims. It's basically optimistic. It appeals to universal acceptance. You don't speak about your justice when you do something very individual in your small world. You actually appeal to acceptance and buy-in from many others. Instead, we are supposed to be much more realistic and maybe even cynical, to the degree that we should become more aware of how complex the conditions in fact are in which law operates, and that then includes a lot of the sociological analysis that we have nilly-willy, more or less deliberately as lawyers, have taken on board. Sociologists have for a long time been arguing that society is in fact much more complexly structured than even traditional political science descriptions, or above all, distinctions in law between public and private, the state and society, would want us to believe. So if society is functionally differentiated, if society is really only an amalgam of very different interactions that all unfold following their own own rules, it's very difficult to speak about justice. How would justice be a term or a label that could apply to all of those? Now, if we understand that the world is very complex, but we strive for justice, for results that actually might make the world better, and we're supposed to actually not really believe in this, but try nevertheless, where are we supposed to get the energy for that? So that leads to the question of agency. Who is in charge of trying to achieve justice? And what are the different models or frameworks that we have available? So there are many, of course. So allow me and forgive me to be relatively crude, because each one of these four now is exaggerated, but I think they represent at least some of the important frameworks and lenses. So one is that it's all about self-regulation. It's all about what can we do in our own form of doing, of changing, of having an impact. And there's very little hope that there is any overarching unity, such as what we would call the state, to take care of it, but it's self-regulation. And the problem about this, of course, and that's, I think, very adequately put forward by the philosopher that I mentioned here, Jürgen Habermas, is that in the 1980s, a huge crisis occurs in Western legal thinking, which is that for many different reasons, the state, as the state government, begins to change its role. So if one maps the development from a very formalist rule of law conception through an interventionist state before the First World War, then in the interim time, and then during the Second World War, to an emerging social state and welfare state in the 50s and then flourishing in the 60s and early 70s, the late 70s and early 80s are marked by a fundamental transformation. I quote Habermas because he analyzed so compellingly that yes, the conservative right is correct in saying that the state cannot finance these luxurious activities of a welfare state anymore, and it's actually time to face economic realities, and globalization is one of those, and to accept that the state cannot look out for all of us, and that we'll see also documented, of course, in political change everywhere. What's very crucial about Habermas's observation that the state is not just financially exhausted, but also normatively, is that Habermas, as a sociologist and philosopher, puts the finger on the wound of the state not knowing enough. And that is important because that's another perception that lawyers have been very familiar with, which is to reflect on the apparatus that tries to bring about change. And we as lawyers, we solve problems. So we react to moments of crisis, to emergencies. But Habermas says, and of course along with him many sociologists say, what are the categories that inform the work that a modern state does? What does the state actually know about those that are on the receiving end of laws, of regulations, of state intervention? And Habermas says we are at a time now where society is so complex that to assume that the state, a public regulator, sits atop of a society that then sometimes receives benevolent gifts from the state, that's utterly naive. So what needs to be replaced, in fact, is the idea of a state intervening with good intentions in society to a much more crucial assessment of the complex processes of interaction, of information flows that have to be facilitated, supported, and solicited by the state, with the help of the state, from different actors in society that often enough first have to be equipped with voice to express their views. So the idea that the state does give, or as the conservatives would then choose to declare, stops giving, that is utterly naive and is much more complex. Hayek is a crucial intervention at this time, and we see that he comes back, his impact is coming back again and again. Hayek says that it's really all about market regulation and market self-regulation. The state plays a very particular role. If you ever read the Constitution of Liberty or some of the very pivotal great essays, not just the Road to Serfdom, but some of the essays where he describes what the role is of a state to coordinate market interactions, you will see that the state provides a merely formalist framework in which free market exchange is to occur. That model is so pervasive still that it keeps coming back all the time. The third attack on the state being the harbinger of redistributive politics and of a law that tries to achieve just outcomes is law and economics. But law and economics is, we could say, and we should actually say today, is the most successful intervention in law and society that has occurred. Because law and economics has been much more successful by using the insights of Habermas and others. Of course, you could probably never prove that any law and economics scholar has read Habermas, but Habermas's and others' emphasis on complex regulatory processes that work through an interaction of public and private, law and economics scholars very early on realized that it's crucial for us to understand how processes unfold on the ground, and then to realize that any state intervention is likely to get the results wrong. Lastly then is the sociological analysis driven to extremes provided by Niklas Luhmann to say that society really is this hyper differentiated structure that I referred to earlier. So it will become much more concrete in a few minutes, but I want to just confront you with this slide. So these changes that you could map when you say, there was a welfare state, then there is a financial and a conceptual crisis of the state in the West, and then eventually we have the emergence of neoliberalism, and we have the shift to market, and we have the Washington Consensus. These things don't just automatically happen, but they are constantly being contested and engaged with theoretically. And so these theories are all around us. None of them is black magic. They're not secret knowledge. They're not knowledge that's so hyper-specialized that only philosophers or very well-educated theorists can deal with them. But these are basically the consequences of asking a few questions of what are the interests that the state does not know yet how to identify, to adequately address, to support and to facilitate. There's a contestation of theories, and these theories are, and that's why I mentioned this, actually real existing political and economic transformative background. These theories are not pie in the sky. These theories engage directly with these transformations that take place and are as such highly relevant. Question for us is, what relevance do they have in our theoretical work, especially if we are constantly, since the 1980s, pushed to either-or takings? So we in fact see that public discourse, and we see that dramatically these days, of course, is marked by being for or against, by being right or wrong. So this is just an early reminder of, if we do not say, and if we are not able to show the practical relevance of this immensely rich theoretical work that's been done in the last few decades, if we are not able to do this, then nobody else will. Because you've never seen a deliberation in a moment of crisis where somebody said, stop everyone, let's talk about the theoretical foundations that we could draw on. If you don't bring it on the table, it will not be on the table. And if you see the progression of these theories, then you can see how scholars across time have tried to give form to very complex issues. And let me just very quickly tell you, some of them might be less familiar. So the two waves of critical theorizing, if you trace the development, Marxist, feminist, race, and then LGBTQ, these things are fragile. These developments, they constitute proposals to highlight aspects that often do not get considered as legally relevant. So the purpose and the impact of theorizing these developments is to show that certain facts are legally relevant and you only capture them through such a framework. Second one is more in the public international law arena and has to do with the growing importance of post-colonial theory for our teaching, study and practice of public international law, which for some, even in this room, is their daily bread. But for the majority of students, even if they study public international law at some of the best universities in the world, they will get a degree and they've never heard of this having taken place. They will graduate and they don't know that for 20 years now, work has been done in about the third world approaches to international law. The attempt to show what are the colonial heritages and roots of formations that we find in present day times. TWAIL, transitional justice and law and development, and what are the relationships between those? Law and economics, the turn to legal cultures. Is that relevant today? Absolutely, in a world that is so hyper-pluralist. Regulatory theories. There's an important work that's been done in the last few decades on the relevance of taking on board hyper-specialized rulemaking, expert-made norms. Is that law? Is it not law? What are the categories that we should apply? Global constitutional law. Is that a crazy idea? Can there be constitutional law on the global level? What does that actually mean? What do people try to tell us when they do this kind of important work? What is global administrative law, GAL? These things are not just some hobbies of people, but if we don't show that they're politically relevant, they won't be. So then, theory redux or maybe revisiting. So in the following few slides now, I'll say a few words about transnational law, basically as a lens that might help us to reposition some of the things that have been going on. So transnational law remains somehow contested. Although I'm so invested in that, I'm growing less and less interested in actually defining what that is, because the work that is reflected in the slide before is so rich that transnational law basically points to the space in which this work happens, which is its border crossing. It has to do with movements of ideas and people, and it challenges our understandings of what is public law, private law, what is not law, what does legal pluralism actually mean in a world where so many norms are created by private parties, or where the concretization of a norm is done by private parties and the general framework, the general law doesn't even tell exactly what the outcome should be. So transnational law, how do we define it? We define it either from what we already know. We say, so this is basically public and private law, but now operating outside of the nation state, or it's something entirely new. It's sui generis, something that we can only describe from inside. So what are some of the references that we have when we look at the formations of law in a global context? So we feel that probably we cannot just analogize from domestic law to what might be emerging forms of global law, but we also know that we don't want to give up on this just yet, because the experiences of domestic law are so crucial and they're so full of fight and struggle and so much bloodletting. A high price has been paid to create domestic constitutional legal cultures, that you can't just suddenly throw this all away and say, let's just see what global law looks like. It's all about understanding the connections between different locally experienced formations of law and struggles over law and struggles over access to justice and the formations that we see outside. So we know that some of the ways of putting order is hierarchies between domestic, national, municipal law on the one hand and international law on the other. We also know that the formations of law that we have available to address border crossing activities are regulated and driven mostly by the function that they have to fulfill, and so that's why we differentiate between private international law, otherwise known as conflict of laws, and public international law, and we think that basically covers it. We also know that a lot of the formations that we now find are driven by very, very heterogeneous interests, but we also know that some interests are more powerful than others. And so business interests might might be more powerful than others, and that's not just that Wallonie had to learn that when they wanted to resist the trade agreement. There is specialized work by a colleague, for example, of mine in London on transnational commercial law. He, of course, stands on the shoulders of people that have been doing transnational commercial law now for close to 100 years, if not longer. For them, the question whether it's law or not law has never been as relevant. It's all about the function that these normative arrangements actually have to fulfill, which is to facilitate global trade exchange. But there's also other forms of border crossing that appears. It's piracy, it's human trafficking, it's organ trafficking. Where do the norms come from that address these phenomena? So now we move from formations of law to foundations of law, and what can we fall back on? So where does legitimacy come from in this increasingly messy landscape of legal formations? Is it religious? Is it Thomas Hobbes? Is it Westminster parliamentarism? Is it the Security Council? Or is this a lawmaking body? Is the G20 meeting, is that just a meeting of powerful people? They discuss policy? Or is it lawmaking? Is Rio plus 20 the best thing we could have before we had the Paris Agreement in terms of setting forward a few standards in global environmental regulation? Or is it just a conference? What is the significance of these formations? Why do I mention those? Not just to paint a colorful picture, but if we don't think a bit more creatively about formations such as those, then they will be irrelevant. But if we ask, can they be relevant? Are things in terms of consensus, which is your colleague Frank Garcia's third take in his book on 2013, the third take about consensus. So where does global consensus, where do agreements emerge from that we could rely on in terms of searching for a liberal theory of law, if not justice? These formations maybe are that. Is the World Social Forum a basis of legitimacy, or is it just a talking club of those that get excluded from other sessions? What's the legitimacy of the 99%? What's the relevance of such formations? So we put these questions of legality and their transformation and questions of contested legitimacy on the table, and we end up with what? A question of how does the law look like? Where does it begin? Where does it promulgate from? Where does it emerge from? Is it legitimate? Is it not? Where do the standards come from? And we end up with a picture like this, which is fascinating but also terribly frustrating. So we see shifts that take place, and if you taught an introductory class to public law, at some point we would have to show our students that it's no longer correct to just talk about the traditional public administrative constitutional law framework, but you have to show that some of these shifts have had a great impact on how law operates. So we move from concrete forms of how a particular law looks, how a particular regulation looks, increasingly to experiments. That's a term that we hardly ever put into the classroom. But how are students and how are we to make sense of experimental lawmaking, of experimental judging, of trying to get it right, but to realize that we actually have to revisit this? We move from government to governance, but that doesn't mean, and we lost 10 years through these fruitless debates because public law has said, no, that's not true. We still have government. It was never the point to say that one got replaced by the other, but huge transformations take place if private actors and transnational forms of norm making start to interact with formally established forms of government. We move also from municipal to global. We realize that some problem-solving processes have to take place on the global, but there's also a dark side. We also see that certain global norm-making and consensus processes have a huge impact on the local. Very problematic is that in many ways now we find that enforcement, although you could say enforcement is a question of political and moral responsibility, which, as we have learned 100 years ago, should translate into legal responsibility. But if you try to tell that to a multinational corporation and ask about their responsibilities for labor and human rights abuses far away, they will say, no, that's a separate legal person and that has nothing to do with us. But we are happy to publish, just like we did in the supply chain law in California now, we are happy to publish our best efforts of eradicating slave labor and other traces in our supply chain. And you saw the cases from 10 days ago. Cases are being brought, and you can show that disclosure will not yield results that are in any way close to what you would have had if you asked for real enforcement. But maybe that's as good as it gets right now. So, what follows from this? What does globalization 2.0, how could that look like? So, actors, norms, processes is a very simple sounding proposal, but I'll try to show a little of how that could be quite fruitful. So rather than saying that states make law and that executive apparatuses are responsible for concretizing those laws and that these laws are laws if they have gone through that process, rather than doing that, a sociologist asks, who are the actors that are engaged in the creation of norms? What different types of norms do we have, and how do the processes look like that generate these norms? So, what are we doing? Are we proposing a new philosophy or theory of law, or are we saying, no, but we will sociologize our understanding of law just a little bit? So, we suggest actors, norms, processes, and we are now overwhelmed by a huge somehow legacy and history already of people saying, no, there's actually much more going on. Transnational law is a project that actually is just about the creation of global markets. Your slow attempts, your careful attempts here to suggest that it's all about legal methodology of doing law in a global context, not very convincing, because we learned early on that it's all about facilitating global exchanges. So that's why it's necessary then to review at least some of the signposts. So Philip Jessup's book, and of course I'm supposed now to tell you that you should read this book at some point because a professor always tells you what you should read. The good news is it's very short, it's 113 or 116 pages, and it's actually quite remarkable because there are 3 theater plays in it. So the style of writing that book is really quite fabulous. But I don't think that a lot of what we do right now was actually on Philip Jessup's, in his recipe book. I think we've gone further. But what we find now is that there's interesting constellations. So when Anne-Marie Slaughter writes in 2004, A New World Order, she writes in a very straightforward way that we are surrounded, and she writes as a political scientist and international relationist, she writes that we're surrounded by a much more complex landscape of norms and processes. Okay, so now what then is behind this relatively ambitious, or maybe just hidden, secretly ambitious project of transnational law? One is to say that transnational law is only a vehicle to ask a few questions over what terms, what kinds of legality have we had so far, and what forms of legitimacy have we had, and that it reminds us, in fact, that we have somehow learned to accept that there is an abyss, a gap, a difference between legality and legitimacy. But if you try to explain that to a child, the child would say that that's not only cynical, if the child knows that word already, and of course our children, poor ones, they know that. But they also realize that it's not logical. Law should, of course, always be legitimate. Law should always embody justice. But somehow it doesn't. Why is that? Transnational law asks us to revisit this because it shows that there's something already wrong in Denmark for a long time. Transnational law is also a lens to trace a few of the developments of norms, of orders of norms that have grown exponentially, and ask who's driving those? Who is in fact doing investment arbitration law right now? Who is calling the shots? Who's doing Lex Mercatoria? Who is behind global financial regulation and I'll say something more about this in a second, one of the most transnational fields ever, unruly, complex, the stuff of books and books and books, the global war against terror. What is that 9/11 law? We have to look at it. So Then lastly, and I already said that, for me one of the most important things is to, when we talk about transnational law, we don't talk about something that takes place outside, but we talk about the connections between legal and political developments on the ground, locally, in different places, about some of whom we know a lot, and often we don't know much more about others. That has to change, and the developments outside. So where can justice come from? And that's a crucial one now. So I want to suggest, very roughly again, there are maybe 3 ways or 3 drivers of transnational law. And we have to ask whether they are also the promulgators, the generators, or the foundations of justice. Unfortunately, the former is only true. It's drivers of law, and that's already problematic in itself. So one is that transnational law formations are the result of problem solving. So transnational law formations in this complex mix of public and private, states, international organizations, NGOs, private actors, these norms get created and incredibly manifested and institutionalized in highly complex ways in response to moments of crisis. And we already know for a long time that he governs the moment of crisis or of exception who calls it that way, and who also is in charge of saying when it's over. So 9/11 law is one of the most important fields in that way for us. Our students, many of whom, for them 9/11 is a historical datum. It's not a marker of what was before and what was after, but it is the way that they have learned to talk about freedom and security. The war on terror and its permanency has become a normality for the younger generation. That's really crucial for us, because 9/11 law is so complex, and 9/11 law was created in the heat of a moment. So if a country such as Canada, where many of the flights got rerouted to, manages in 2.5 weeks to create a legislative package that changed 200 laws in the Canadian legal DNA, that should make you think. So you can change 200 laws in a matter of days, but how do you execute that change? How good are your control mechanisms to see what has happened to those norms? Who looks after sunset clauses? Who looks after, is there still a standing committee that has anything to say? Has that work been done? Is there a promulgation, a proliferation of these norms? Who's in charge of these processes? A happy side, maybe, is climate change law. So the diffusion of norms, as different scholars have called it, the global diffusion of norms in a more hopefully forward-looking and optimistic way, is climate change law. 9/11 is the dark side, climate change law might be the bright side. The same complexity of lawmaking, of actors, norms, processes, but hopefully with different results. The second option is the one that many people in Europe still like, is to believe in overarching theories. So you have to have a grand narrative, a theory, a concept, global constitutional law, global administrative law out of New York. These are overarching concepts, but once you look at them a bit closer, they really only live, and they can only live if they work in small detail and on the ground. But they're important because they are about utopias. They might inspire. They ask us to put on the table our differences and see why we have these. Lastly, the normatively most modest one is to just say transnational law is a revival of social legal studies. It's a revival to look at concrete facts and then not to go crazy in trying to derive major theories from that. If you had to say which of these options correctly describes the emergence of transnational law, most likely one would have to say a mix of all of them. So where is transnational law? Where are these norms located today? It's very important to briefly now that the map has become much more complicated, to remember of what we mean when we used to exclusively or predominantly associate law with the state. What did we mean by that? It's important because if we actually look a bit more closely as to what we mean when we say the state, then a lot of that can be rescued into this transnational arena. One is that the state is a fact. So it's a historical experience And once we start a dialogue over how people in different parts of the world in different times have experienced that emergence of the state, then you actually know, you begin to hear different opinions over what is actually at stake. It's not just the state as formalized and abstract by Friedrich Hayek, but it's the state as it exists in different concrete formations. It's also an achievement, which is also crucial, and again, these days so important. So the state as a forum in which we have fought for norms, and we have fought for norms and for legal triumphs, even if we then had to see that you win in court, but the world doesn't change tomorrow. But then we do it again. The state provided that container, and so the state is also an achievement, because it provides us to be part of this, and we're not being asked why. It's a normative appreciation. We tend to rely on the state to get things done, and sometimes it actually can get things done. So the foundations of that state, of that 20th century experience of the state, now through the vocabulary of actors, norms, processes, is nothing postmodern at all. The actors are the state, administrative agency, etc. The norms are treaties, conventions, regulatory acts, straightforward. The processes are democratic deliberation, then we have to engage in how well they work. It only becomes interesting when you contrast that to what the map looks like today. Map now is much more colorful. The map before is still there. So we haven't moved on into this new realm, it's all gone. We still have laws, we still have regulatory acts, we still have deliberations, we still have rules that govern behaviors in congressional conventions. We have all of this, but we also have now a multitude of other things. So we have other actors. We have in fact now a hugely grown role of private actors to generate norms, to formulate the content, and to make sure that they work. We have a hugely important role of NGOs. If you look at some of the Security Council resolutions, and you contrast that to the state of development in public international law theory over whether NGOs are proper subjects of public international law, in Security Council resolutions you find so many hints already to the role that NGOs play that answers for itself. Questions of movements of individuals, which role do we ascribe to them? The norms. So yes, we have laws and treaties, but we also have codes. And in some of the most crucial, or in many crucial areas nowadays, that are considered politically too sensitive, where we could never have a political consensus, we accept that private parties will promulgate a norm, and then we can hold their feet to the fire. But what fire is that? We can name and shame them, but we often can't enforce them. But we live now in a world of norms, but we also have accords, such as the Bangladesh Accord. Is that a law? Is it not a law? Is it a new form of transnational labor law? Or is it just an agreement that most corporations now try to come out of? What's the regulatory nature of data? The work from the last 10 years on indicators. What is the legal nature of these data, and how far do they actually govern us? The processes. And the last year, unfortunately, has been this sobering moment for all of us, everywhere. What happens to the classical, traditional modes of voicing your political opinion? Where is Vox Populi, the voice of the people? Okay. So this is not advertising. This is just an illustration. So when we want to now take this, what I've suggested here, out of this world of grand theorizing and a lot of sociology and a lot of political science and interdisciplinarity, and to just say, okay, we do all of this work just like we've been doing theoretical work before, but it only matters if you can translate this into what we do daily. Then that works by not saying everybody has to have a seminar in transnational law. There shouldn't be such a seminar. What should be is that we teach the materials that we have and the fields that our future graduates will work in, that we teach them with a view to these changed conditions. And that means, for example, that you say a corporate law class today that does not make references to labor, because we continue to say that workers have an employment contract, they are stakeholders of the corporation, but they're not part of the corporation, has very little to do with the lived reality that surrounds us. So we have to create those alliances. Criminal law, taught just as criminal law, but then students take 2 years later a seminar in war against terror or security law. It should already be part of criminal law. Climate change governance, yes, but you also have to understand the economics of carbon trading, not just be a public lawyer who eventually becomes an environmental lawyer or transnational environmental lawyer like TL. Rule of law export, yes, but also then really put investment arbitration law on the table. Governance through disclosure, that's all fine, but give real-world examples such as WikiLeaks and Panama Papers. What is the legal relevance of those? Global constitutional law, I already said that, and post-colonial law and development and or transitional justice. These two fields should be one. Okay, lastly, can I have 3 more minutes?
Yes.
Okay, so what does this mean? Words teach a lot, but actually examples bring it home. So my example is this one. It was very predictable that we have to talk about this. So the FIFA scandal, I presume, of course, for most of us, we know that it's about workers in Qatar. But somehow, the legal news about FIFA that made it into every newspaper were not the workers. In some papers, yes. In New York Times, in The Guardian, yes. But it was all about the rules of extradition. And how is it possible that you can enforce a RICO norm somewhere in Switzerland? Is that possible? Is it not possible? Very interesting questions. But what actually lies behind this? So you follow the little history. It's scandalous, it's breathtaking of what happened. No, the arrest of the officials, now cases are being brought. You learn about coexistence of private ethical codes within FIFA and the attempts of bringing proper claims against them for corruption. But of course we know that there is a story behind it. One of the links to that story behind it is Ruggie's report, right? And that's why I said, if you begin to think creatively about where norms come from, then you find them in academic places that eventually become highly, highly politically relevant. So you all know that people that study human rights and multinational corporations have been living in this world created by Ruggie and his universe for, I don't know now, 6 or 7 years. John Ruggie was asked by FIFA to write a report for them on how this organization can reform itself. There's a video, there's a report, not very long, very fancy, nice, and then there's a video that FIFA made. It's 3.5 minutes and we don't have time, but if you click on it, then you can see it. What we all care about, which is what is the role of FIFA in having these tournaments that leave countries in a wreckage, that have outrageously negative impacts on the people on the ground in these different places. None of this occurs. It's about putting a woman on different decision boards, on pluralizing, they say, the decision-making processes. It's incredible, really incredible. You have to look at it to believe it. Okay, so then very quickly about Qatar. Why do we care about migrant workers in Qatar? We learn about this just as we, in a labor law course, if students were still to take labor law or maybe in corporate law, we expose them to that and say, what's the legal story behind it? What law applies to these workers? And they would say, well, I don't know, I guess Qatari labor law. And you say, well, okay, start looking for Qatari labor law. And what you find then is that there's a difference still between domestic municipal law on the ground, but that law now you cannot understand anymore if you don't see it in its connections to international law and to soft law. And that's the constellation one has to study. So we learn about the working conditions, and now we ask what different norms of law interact here. Now I'm almost done. So you look for hard law first, as every lawyer should do, right? You look for hard law and you see that Qatari labor law has in fact been undergoing tremendous change. Something that you would never have imagined before because it's far away. You didn't even think of labor law that exists there. Not only does it exist, but people are contesting it. People are trying to reform it, and you have to study it from the inside, which might mean you can't do it from an abstract vantage point anymore. You have to go and talk to labor lawyers on the ground there. It comes perhaps in hard form, in the form of ILO conventions. but how many people have ever heard of the ILO and what it does? And what's the impact of those conventions? But then there's this universe of soft law. So what is the relevance of the so-called Ruggie principles that he elaborated in the UN framework a few years ago? What is the regulatory function and also weight of the FIFA internal ethics code? What is the legal status of the arrangements now between different companies, trade unions, newly formed coalitions of trade unions and corporations? Who are the drivers? Who in fact is the population, the set of actors that drive regulatory developments here? If you've never started to develop a sociological perspective, how will you find those? Because you would say, I will apply a case, but there's no case. So you have to reverse the perspective from learning judge-made law to how would I as a lawyer build a case? Who do I need on my team? Where do I need to look? What can I argue to say that a certain fact is legally relevant? Because if you read only cases, then that decision has long been taken, and hardly ever does the decision make it clear why something is considered relevant or not. But you have to tell the judge why a particular element is legally relevant. And if you live in a world of soft enforcement and public disclosure, then maybe a public statement by the CEO or chairman is legally relevant because it might be the only thing you can stand on. So then, what do you do when you develop a legal strategy? Where do you begin to sue? Who is the right addressee? How to develop a case that has to work with so many different variables? Do you go directly against FIFA? FIFA will say, well, we have not employed a single worker, but it's part of a process of making public. Do you go against the Qatari government for not enforcing the labor laws that they have? Do you sue Qatari local companies? Do you go after Western-based companies that have their business interests there? Do you try to litigate a company for financial compensation, or do you try to change conditions on the ground? Do you work for the change of categories, different corporate liabilities? Do you say there should be a tort for negligence of badly executed corporate supervision of a mother company of its subsidiaries? What if it's not a subsidiary, it's just a contractual partner? What is the law that governs global supply chains? What is global supply chain law? Is it contract, tort, corporate law? So one pursues these legal avenues that we've all been learning, but now in parallel, one also looks for how do these cases look on the ground? What do the actors on the ground actually try to achieve? Do they try to just walk away, get their passports back, as the migrant workers give their passports, and just go home? Or do they want to work under different conditions? How do you create that regulatory regime? What's the role of the lawyer who's no longer just a litigator, but an advocate? And that's the world in which they operate, right? They have these different reference points and legal areas. Okay. 60 seconds. So every student learns in the US the Lochner case. They learn the Lochner case, and usually still Holmes's descent, but often not Harlan's descent, because it's not so spectacular. In my view, it's absolutely spectacular. But what's so remarkable about contrasting the Lochner decision from 1905 with the Qatari decision, or the Foxconn suicides in China, or the Bangladesh Rana Plaza disaster, is that Lochner is a case that we could rip our hair out because it makes us so, it engages us. But in fact, in Lochner, you have so many things in place that you don't have in place anymore. You don't have a constitutional text to rely on. You don't even know now in Rana Plaza which court to go to. You don't know much about the corporation. In Peckham, with Peckham's judgment in Lochner, we also learned nothing about the factory or its workers. It was all highly abstract. It was all about freedom of contract that was allegedly embedded in the Constitution. But at least we had these reference points. The company was without question considered as a private actor, and therefore it should preserve the right to contract freely. These constellations of global supply chain networks, are they public, are they private? what is the responsibility of a so-called legally private corporation for all these workers? Is it still only private? So yes, there's an employment contract, or is it something else? So it can be very powerful to contrast a case that is so contested in itself with a constellation where you don't have that case. And how does the interpretation of Lochner influence our understanding of these transnational labor conflicts? Okay, that was my example. Thank you so much for your attention.